Thank you very much and welcome back for this afternoon session on the non-judicial legacy. We're actually going to pick up a little bit on some of the issues that have been raised this morning, but in a way go a little bit deeper in the analysis. So it's been really good to see that issues in relation to the actual mandate of the court, as well as the bigger picture, has already been raised both in the welcome remarks, but also in the context of the various presentations so far. So we're going to continue on this and go towards a discussion with four very diverse panelists, in the sense that we're going to touch upon law, but also political science and broader interdisciplinary research that they've all done. In a way, the issues of deterrence, maintenance of peace, issue whether or not a court, even if it's not its mandate, can contribute to reconciliation. It's a very difficult topic to address in the abstract. And so I'm really delighted that this afternoon we can actually go deeper, look into case analysis, field studies that all of these experts conducted on various different aspects of it. So for this to happen, I have first Marko Milanovic, who is Associate Professor in Law at the University of Nottingham. And he's going to talk first about the reasons why audiences in the former Yugoslavia have not necessarily accepted the facts and narratives of the ICTY. We'll then continue with Rosa Aloisi, who is Assistant Professor of Political Science at Trinity University. And she's going to take us to a field study of memories that she's conducted in Bosnia-Herzegovina. We're going to follow with Jacqueline McAllister, who is Assistant Professor of Political Science at Kenyon College. And she's going to take us on an analysis related to the ICTY and its ability to deter atrocities. And then finally, we'll have Jenny Natalia Clark, who is going to present her research on the ICTY, truth and reconciliation. Because all our four panelists have PowerPoint presentation, I'll just ask you for a little bit of patience with us for this afternoon. Thank you very much. Marko, if you want to start.
Well, thank you very much, and I'd also like to thank the ICTY for inviting me here. It is a pleasure to address you all and to speak about why the ICTY failed to persuade target audiences in the former Yugoslavia that the factual findings about mass atrocities that it made in the course of its judgments are actually true. As you can see from the way I explained what I will talk about, that assumes that the ICTY did fail. So let me first explain how we actually know that this is a fact. We know that it is a fact that the ICTY did not manage to persuade people in the former Yugoslavia, not simply on the basis of anecdotal evidence, but on the basis of increasingly rigorous empirical research. And Janine will also be talking about later about the empirical research she did. But I will focus on, first I will focus on some surveys of public opinion that many of you will probably be familiar with already, that were done by the Belgrade Center for Human Rights, the OSCE, and Ipsos Strategic Marketing in the various countries of the former Yugoslavia, so in Serbia, in Croatia, and in Bosnia, and two different surveys were done in Kosovo, not as part of the Belgrade Center project. That was led by the late Professor Vojin Dimitrijević. So what do these surveys show us? So here you have, in this pie chart behind me, you have a question that was asked of the majority ethnic Serb population of Serbia. Do you know, as far as you know, what happened in Srebrenica, the worst crime, as you know, of the Bosnian War? And you can see from that pie chart that only 10% of Serbs living in Serbia, this is 2011, but the situation is probably exactly the same today, believe in the facts about the Srebrenica genocide in the exact way that the tribunal established them. Everybody else, 90%, engage in some kind of denialism. Now, they engage in different kinds of denialism, but that's what they do, right? So the first big chunk, the 36%, you will see they accept that a crime happened in Srebrenica, but they say much fewer people died than 8,000 Bosnian Muslim men and boys. Yeah? Then you have people who say, no, it was only casualties in battle. Then you have people who say, no, there was nothing. And then you have a big chunk that says, I don't know, or I refuse to answer. But the answer that they give, again, is that only 10% of Serbs in Serbia believe the facts about the worst crime of the Yugoslav wars as the tribunal established them. Here you have the Bosnian survey. The first two bars on the graph are the federation respondents. So you would assume on the basis of their ethnicity, they would be mostly Bosniak and Croat, right? The second two parts of the bars on the graph are Republika Srpska respondents, so mainly Serbs. And you can see how in this country, right, the communities in this country live completely parallel realities. Yeah? So whereas 63% of Bosniaks and Croats heard about the ethnic cleansing of Bosniaks from Bijeljina, only 11% of Serbs in Bosnia say that they heard of this event, and only half of those who say they heard about it believe that it happened. So you can see for some of the worst crimes in the war, including the Prijedor prison camps, you will see that the percentages of Serbs in Bosnia who believe that the crimes happened the way the ICTY established them is in the single digits, right? And even, I mean, perhaps most shocking is Sarajevo, so the city we're in, right? Where basically only a quarter of the Bosnian Serb population accepts that there was a siege in which thousands of people died. Yeah. The same goes for Croatia and Kosovo. So I'm not gonna spend much time on this. Essentially, Croats believe in crimes that happened against Croats, but they do not believe that Croats committed crimes against Serbs, and vice versa. The same thing when it comes to the relationship between Serbs and Albanians. Serbs believe in crimes committed against them by Albanians. They do not believe they committed crimes against Serbs, and vice versa. So for example, here you will see, these are graphs which represent the population of Kosovo. You will see that about 75% of Kosovo Albanians refuse to accept that members of their ethnic group committed crimes. Yeah? So that's what the surveys tell us. The surveys are methodologically rigorous. So if you're interested in this, we can talk about this further, but they are done with proper polling methodology and representative samples, et cetera, et cetera, et cetera. And the picture they paint is a very bleak one. People in the former Yugoslavia believe in the existence of crimes when it suits them, when it confirms their own narrative of victimhood and perpetratorship. When it does not suit them, they disbelieve them. Okay. So essentially, the survey results are driven by ethnic bias. We also have a question in the survey that asks people, do they trust the ICTY? And you can see that two groups that have some levels of trust in the ICTY are Bosniaks and Albanians, whereas Serbs and Croats hate the ICTY's guts. And the reason why this is so is not because Bosniaks and Albanians are somehow inherently more predisposed to trust international justice. It's simply that the bottom line of the ICTY's jurisprudence is more aligned with what they want to hear than with what Serbs want to hear or with what Croats want to hear. Okay. There are limits on the surveys. So the surveys, for example, will only tell you what the respondents say. We have no idea of knowing what they actually think. So some of the respondents are lying. In any survey, you will have deceptive respondents. And in these surveys, they touch very difficult questions of identity, ethnicity, and so on. A big chunk of them will be lying. So for example, one graph that you will not see here shows that Serbs in Serbia know more about crimes in Bosnia than Serbs in Bosnia. And the only explanation for that is that some of the Bosnian Serb respondents are more inclined to be deceptive than ethnic Serb respondents in Serbia. Okay. The reality, however, is basically as I presented it. And the question is how to explain this. There are two basic explanations. One that I think is implausible, which is that actually people in the former Yugoslavia do agree, privately, in their heart of hearts, that these crimes happen and the ICTY is right. They're just deliberately lying. Yeah? The other explanation, which I think is the valid explanation, is that you have a few of these people who are deliberately lying, who are cynical manipulators of the truth, right? But that the vast majority of people are normal people, decent people, otherwise normal people who you would go to have a coffee with, yeah? Who, if something bad happened to you, they would help you. But they are still somehow led to a very amoral position of denialism. And so the big question is this: how do otherwise decent people begin denying mass atrocities? And the explanation for that question can only come, I think, from social psychology. It's a psychological explanation that is required. So basically, I wrote a series of articles, if you really want to, the whole shebang, in the American Journal of International Law and the Georgetown Journal of International Law, where you will find some of this literature and an extensive discussion of the psychological stuff. Essentially, my argument goes that all of these people engaged in modes of reasoning that are meant to protect their identity, that they are driven by biases of which they are largely not conscious. So they are led to certain results while they continue believing they're actually objective, moral, upright. Yeah? So what, in fact, you have is different communities with their own, each with their own different parallel reality. There is not a single reality that is empirically verifiable. There's a Serbian reality, an Albanian reality, a Croatian reality, a Bosniak reality. And I like to call this the Wikipedia approach to reality. Why? Because people agree, essentially, within each of these communities what the official standard narrative is. And in fact, if you, and many people here speak Serbo-Croatian, if you go onto Wikipedia, you will see there's not only an English Wikipedia, there's a Serbo-Croatian Wikipedia, there's a Serbian Wikipedia, there's a Croatian Wikipedia, and there's a Bosnian Wikipedia. There are 4 Wikipedias in the same language. And why do we have 4 Wikipedias in the same language? Because they are propagating different realities in each of these. So essentially, if you go to, and look at articles about Srebrenica, about crimes in Croatia, about crimes committed anywhere during the war, but also events from further history, for example, the history of World War II, history of World War I, you will see how each of these communities has their own version of reality. So how do we explain this? I think this identity protective mode of reasoning is driven by a combination of internal subjective factors and external objective factors. First of all, you have an enormous amount of empirically, experimentally verified research in social psychology that proves how bounded human rationality is and just how biased we are when it comes to everyday reasoning. For example, confirmation bias is one of the most well-established phenomena of social psychology. It means that once you first start believing something, any information about that particular event or issue that you receive later on in life will be assimilated in a way that confirms your prior beliefs. Beliefs that you acquired through your family, through school, through your wider social context. We engage in motivated reasoning. What does that mean? We do not simply reason in a way that we want to find out what the truth is. We reason in a way that goes in furtherance of some goals that are not simply associated with truth. Like, for example, we want to look good, and we want our group to look good. Similarly, research has shown how emotion and cognition are completely intertwined. There is no rational part of the brain and an emotional part of the brain. People in the former Yugoslavia do not have a thinking, rational view of what happened during the wars and an emotional view. It is all one view. They feel the truth. They don't know the truth, okay? So it is this power of emotion that is the big driver of biases in this whole set of issues. Then we have the objective external factors. The first one is distance. For the overwhelming majority of people, the existence of any crime is not something they could see with their own eyes. You know, Serbs in Serbia were not in Srebrenica when it happened. They could not observe it directly. We always have to rely on others for the information we then choose to believe. The others are politicians, media, elites, all sorts of intermediaries. That is especially true of intergenerational transmission. So people who are now 20, and they were born after the war in Bosnia, they have to rely on their families, on school, whatever, for information. They do not have time or expertise to process this information. They will reach outcomes, views, in a very quick, superficial way, in a way that aligns with what most people in their peer group believe. So, I'm concluding. The bottom line is this. If we had a perfect ICTY that was funded 10 times more than it was actually funded, where every judge was like the judges in front of me, a genius. Not every judge was a genius. Where every legal officer was a genius, where every prosecutor was a genius, yeah? The situation would be as depressing as it is today, right? So the ICTY probably made some things worse than they could have been and some things maybe a bit better than they otherwise would have been. But the reality, the sad reality that we live today is not the ICTY's fault. Yeah? Second, it is illusory to think that people will wake up one day simply because you present them with enough facts. There is no magical tipping point where you provide people with enough evidence that causes them to change their minds. Yeah? You have people who deny climate change, who deny that there's no link between vaccinations and autism. They're not persuaded by yet another study done by academics somewhere. Yeah? They feel a truth rather than know a truth. So there has to come a point sometime later in time, yeah, where an emotional appeal to people can be made that maybe has some kind of chance of changing their views. And that time, unfortunately, has not come, and it may never come. Yeah? So I'm really finishing with this. It is naive to think that things get better over time. Things consistently get worse over time from human experience, okay? And I don't mean the guy on the right. Look at the guy on the left. The guy on the left is the Japanese Prime Minister Shinzo Abe. Today in Japan, 70 years after World War II, denying Japanese war crimes is a perfectly mainstream thing, okay? Perfectly mainstream. It's not like in Germany, yeah, where it is done by a radical fringe. Why is it perfectly mainstream? Because you have a continuity of Japanese elites that have undermined the whole idea of finding justice for Japanese war crimes. 7 out of 10 past Japanese prime ministers are sons or grandsons of former Japanese prime ministers. This guy is the grandson of a Class A war criminal called Nobusuke Kishi, right? He, like many other right-wing prime ministers of Japan, every year goes to a shrine, the Yasukuni Shrine, where the Japanese war dead, including the war criminals, are honored. And if you go to that shrine, you will see, you will see this. Oh my God.
See, it actually tells you it's over.
Exactly, sorry. You will see that. A memorial to the dissenting judge in the Tokyo trial, who he, lauds for his brave spirit of courage. So I can imagine here in Bosnia and Serbia, dissenting judges being honored by those kinds of memorials because they align with the truth these people want to believe in. Thank you.
Thank you, Marco. It's a great, very sobering way of starting a panel. We actually are going to pick up on some of the issues that you were saying about identity, but looking a bit more towards question of memorialization. So we're going to take it to a bit of a different angle with Rosa on my left. Thank you.
Thank you. Thank you for the introduction, Aurélie. Well, let me start by thanking the ICTY for inviting us here and sharing our perspective on the legacy of the Tribunal, our academic perspective on the legacy of the Tribunal. I'm very much looking forward to 3 days of productive conversation about the legacy. And I'm also glad I'm actually presenting in the afternoon after the introduction by the President, Ajus, and Mr. Brammertz, simply because my research speaks about of the legacy of the Tribunal in terms of one of the major concerns that are ongoing right now, which Mark also talked about, which is the denial of the crimes that have been committed in the territory of Bosnia and Herzegovina. My main point, what I'm trying to do with my field studies, is looking at the historical and legal record that has been established by the ACTY in the past 2 decades or more, and assess whether and if that record has shaped in any way or form the memorialization of the sites of crimes. And I'm specifically looking at the sites of crimes because I think that that is, for the victims that still live in the community in Bosnia and Herzegovina where the crimes have been committed, a constant reminder of the suffering that happened during 1992-1995. So I'm comparing, I'm doing a comparative perspective between what the Tribunal has established in its judgment in the Memorial Awards. I called the judgments Memorial Awards, and what is going on those sites that are indeed described in many of the judgments of the Tribunal. I'm going to start just with, I'm going to start with something that is black. Sorry.
Different arrows. So
it's the other one. It's here. So could you please start it again? Sorry about that. It's the one under it?
Yeah.
Okay,
yeah,
yes. I'm going to start now with something that is, I think, very familiar. You're all very familiar with this image. This is a plaque that was erected in the Straziste cemetery, Bosnian Muslim cemetery in Visegrad, in 2012. On the 23rd of January 2014, the plaque, which read, "To all killed and missing Bosniaks, children, women, and men, victims of genocide in Visegrad," the word genocide was chiseled out from the plaque from a considerable amount of police force that were present just doing that kind of work. Against a very small amount of people protesting the actions of the police per se. So it was a show of force to indicate that the word genocide was inappropriate because genocide had not happened in Visegrad. So this is one of the forms of denial from which I pretty much started my work, because this action took place very publicly, and it was published in many newspapers and made international news. What I want to see specifically is what does it mean memorialization. I believe that the ICTY has accomplished several goals that were included in the mandate of the United Nations Security Council. Of course, accountability. There is a lengthy record of individual accountability, of individuals that have been prosecuted and found guilty for the crimes that have been committed. As I mentioned, I think that if you read the judgments of the tribunals, you really find the memorial awards. It's not just a legal statement of facts, it is an expressive indignation for what has been happening in Bosnia and Herzegovina during the years of 1992, 1995, and a little bit later than that. And also the judgments are the voices of the victims. We see that, and we also saw previously in the previous panel, that international criminal justice has moved toward a more victim-centered type of justice. And we found in many of the judgments of the ICTY that the victims have been given a good amount, an extensive amount of space to express their pain, their suffering, and the stories that they wanted to say, as well as in the courtroom. One of the problems, however, two of the problems, however, that have been pointed out also by other scholars is that the International Criminal Tribunal for the former Yugoslavia seems to be emotionally, geographically and emotionally distant from Bosnia and Herzegovina. It lacks that bridge, that connection with the local population. As a matter of fact, Marco was also explaining a little bit of that. And many criticize the sentences that have been handed down by the tribunal as too lenient sometimes, as something that is not appropriate for the type of crimes that have been committed. So I see memorialization of the sites of mass atrocities as a way of bridging, first of all, the geographical and emotional distance between the ACTY and the local communities, but I also see a way of memorialization, a way of acknowledging the pain and suffering of the victims, of making sure that if they are passing in front of a building that was the site of a detention where torture and horrible crimes were perpetrated, they have a place where they can stop, they can mourn, they can be respected in doing that, and they can show the sorrow for the events that have affected them and their family. The reason why I, very quickly on my theoretical argument, I see, generally speaking, memorialization has this form of justice that is coming out of the tribunal and getting into the local community. But I think that memorialization has a twofold goal. One is for the victims, as I was telling you. So it's for the victims to be acknowledged, to have mourning side, to have validation of their pain and suffering, to feel that they have empathy from the population, and they can actually, without fear, say that they were the victims of atrocious crime. And also, I see memorialization, as I said, bridging the distance between The Hague and Bosnia and Herzegovina. But I also think that memorialization is particularly important for local communities at large. There is a say that a Hitler, a Stalin, or any other political leader that has committed several crimes and atrocious crimes against the community would not have been able to do so without the help of the community. So we need to understand that the community at large, the bystanders, also carry a little bit of responsibility, if not more than a little bit of responsibility for the crimes that have been committed. And memorialization is a way of also reminding the young population that those crimes were the crimes that were pretty much crushing down the dreams of the future of Bosnia and Herzegovina, the future of a society that is meant to actually flourish now that hopefully we are coming down with something more than just war. So what I'm going to just show you is a very brief summary of the field studies that I did. I would like to thank right now, before I run out of time, Hikmet Karcic and Samir Sabinia, who are now in the audience, for their invaluable help in driving me around and just pointing out the several places that I wanted to visit. And I'm going just to do a brief comparative analysis of some of the sites that I went through. This is Kravica Warehouse. Kravica Warehouse was the site of a horrible massacre which happened on the 13th of July 1995. We know that there were also several mass graves that were found close by. That is, in a nutshell, the historical and legal record that has been established by the tribunal in the appeal judgment of Popovic. Now, I drove by Kravica, and if it wasn't for the person that was taking me, Samir, I would not have noticed the place. This is how Kravica looks today. This is how it looks on the left side for you from the street. Apparently the trees were not there before. The warehouse is being covered. And if you enter and you go in and you just see the bullet holes and everything is being left the way it is, no single plaque of memorialization that 1,000 men had been killed on the 13th of July 1995. Ironically, however, if you pass by, there is a plaque commemorating a young boy dying from an accident, from a driving accident. Focia. Focia is one of those cases that unfortunately have been extremely powerful in terms of promoting also the concept of rape as a crime against humanity, as a weapon of war. Focia was the place where with Kunarat, Skovka, were pretty much enslaving and raping women in houses and in buildings all over the town. This is the historical record, the legal factual findings that have been established by the Tribunal. However, if you drive through Focia, and this is one of the witnesses testifying about the brutality that took place, and you can find the testimony on the CTY website. If you drive through Focia, through some of the sites where these crimes have taken place, that is the school, the high school of Focia. Yeah, nothing, of course, the school has gone back to its regular operations. Again, there is no indication of the crimes that have happened. What you see, however, on the left, on the right side, it's a memorial to the Serb soldiers that have fallen during the war. And it's at the very end of the town as you go out of the town. Next to the building. I think this is the case that probably struck me the most. Again, I started with the Visegrad Cemetery, and I'm going to stop with these case studies and then I'll give the word to my fellow panelists. This is the case that struck me the most. Visegrad was probably one of the crimes committed in the most atrocious way. This is probably also one of the quotes that you may find very often in several of the papers that academics write about international criminal justice. It is the description that Judge Robinson gave of the crimes committed in Visegrad, where women and men and children were burned alive into houses, respectively in Pjorniska Street and in Bikavac. It was one of those experiences that struck me just because if you go there, this is what you see. The one on the left is the house in Bikavac. It's been rebuilt completely. We were lucky enough to be able to talk to the owner of the house when we were there, and he said that he doesn't really know what is going to happen to the house. He said that very likely there is going to be a plaque that will commemorate what happened, probably visible from the street, but he wasn't really sure what he will do with that. What you see on the right is the house on Pjorniska Street. It's been also vandalized. When we were there, there was dirt on the side of the house. And here you see that only the ground floor is being left as it was when the crime had happened, with a sign of burning. And that's the plaque that is in commemoration of the crime committed. In order to see that plaque, you need to jump into a ditch. There is no way you can see it from the position where I was. Just concluding very quickly, I think the outreach has done an extremely important job and a very good job of the CTY, reaching out. If you just go through the website of the CTY, through their webpage, you can see that they've reached out to communities, they've reached out to young population, they've given educational opportunities to young lawyers. Where we go from here, because we're talking about legacy, probably now we need something more at the local level. We need probably civil society strongly committing to reminding everyone that we have a record, we have an historical record, we need to remember, and we need to acknowledge the pain and suffering of the victims. Thank you.
Thank you very much. I'm sure we'll come back to those issues in the context of the discussion about the way forward, but I just want to make sure we hear from everyone first. We're going to actually move to another side of the puzzle, and I think it was really interesting this morning that Jennifer mentioned deterrence and the difficulty of evaluating how you can deter. So this is what the next presentation is about.
Dobar dan and dobrodošli. So first off, I want to thank our moderator as well as my co-panelists for their very interesting contributions. I also want to thank all the ICTY staff that made this event possible, and most importantly, I want to thank all the veterans, activists, politicians, ICTY judges, prosecutors, investigators, and so on that took the time to share their experience with me as I conducted the research for today's presentation. Without their generosity of time and expertise, we wouldn't have the study that I'm about to present to you today. I also just wanted to preface up front that I only have a short period of time to share my results. I have many more results. There's a paper I prepared for the Legacy Dialogues I'm happy to share with participants. It's in English. At the end, I have my email. You can contact me directly to get the complete version of this work, and I'll just give you the highlights today for time purposes. So as mentioned, my focus is on international criminal deterrence. So as many of you are likely aware, the ICTY's founding statute did mention the goal of deterrence. So specifically, it expressed the hope by prosecuting serious violations of international humanitarian law committed in the territory of the former Yugoslavia, that the tribunal might, quote, contribute to ensuring that such violations are halted and effectively redressed. So my research specifically looks at three questions. So the first question is did ICTY prosecutions in fact affect combatants' use of violence against civilians? If it did have an effect, how did it have an effect on their use of violence against civilians? And again, assuming it had an effect, when did it have this effect? What kind of contributed to those moments? So a couple things to point out here. So I focus on violence against civilians, which is one main tenet of international humanitarian law violations, but by no means the only one. I did that just to narrow the scope of my study. Also, I focus on deterrence while the conflicts were still happening. So I know there's been some research on post-conflict deterrence. My focus is very much on atrocities while the wars were still occurring. So why are these questions so important? Obviously, we're here for the legacy dialogues. It's important to look at the ICTY's mandate and establish whether, in fact, it was or was not achieved. But the question about the ICTY and its role in deterrence has broader implications. So mainly, the hope of deterrence stemmed from a desire of policymakers and scholars and activists to alleviate the immense suffering of civilians during times of war. There's been an ongoing discussion amongst scholars about international criminal deterrence, and I'm sure many of you have heard about the peace versus justice debate. There's very contradictory perspectives on whether or not the threat of prosecution during wartime can have any impact on violence against civilians. Some argue it might make it worse and prolong civilian suffering by taking bargains off the table. And then some say it can make it better. But part of the reason why we have such contradictory views in the existing scholarship and policymaking community about international criminal deterrence is there's really a dearth of empirical data, and a lot of the evidence is incomplete. So people are looking at pieces of the puzzle, but not the puzzle as a whole. So the ICTY's experience is a really rich place to look to answer questions about international criminal deterrence. So specifically, the ICTY, as many of you know, had very extensive and varied experience from throughout the wars associated with the breakup of Yugoslavia. So it went from being a tribunal, as we heard about this morning, that didn't have borrowed robes, they didn't have facilities and so forth, to a tribunal by 2001 which apprehended and started prosecuting, or trying, Slobodan Milosevic. It also confronted a range of combatant groups throughout the course of hostilities. There's a wealth of data available for these conflicts, which is very difficult to get for other tribunals involved in active conflict situations. And the other thing that's important is the fighting, at least in these conflicts, is long over, so I can see if individual incidents from these conflicts did portend larger trends in terms of international deterrence. So the ICTY's experience is really important, both for legacy purposes, for broader impact purposes, and for research purposes. So to begin to study how the ICTY might have affected violence against civilians, I drew on various literatures. So I did a deep dive into criminology literature. I also looked at the literature on civil conflicts as well as international legal compliance. So ICTY was set up to basically ensure that there were legal punishments for international humanitarian law violations. Criminologists tell us that the threat of legal punishment can deter crime when those legal punishments are certain, severe, and swift. In such cases, committing crime becomes costly and thus less likely to occur. Something else that's really important to stress about criminology that's oftentimes forgotten about in policy circles and in the wider scholarship is that when criminologists look at the threat of legal punishment, they don't see the threat of legal punishment as just having to do with an arrest or a formal legal punishment. They also underscore that there are social dynamics associated with the threat of legal punishment that can really affect people's calculus about whether they should engage in a crime. So the court calling out a behavior as potentially unlawful or unlawful can send a powerful signal to actors about the perpetrator that might prevent them from committing the crime in the first place. So I argue, drawing on this criminological scholarship, that in cases where the ICTY could make sure punishments were certain, severe, and swift, they might have had a chance of deterring war crimes. So you might be asking yourself, well, when was the ICTY ever likely to have a chance of making the threat of legal punishment certain, severe, and swift? And I argue that three factors had to be in play. So first off, and the first factor, and it won't be surprising to many in this room, but it sometimes is to political scientists, is for any certainty of legal punishment to exist, the ICTY basically needed to be able to investigate and try international humanitarian law violations in the first place. It sounds like an obvious point, but when you consider the context in which the ICTY emerged, unlike Nuremberg and Tokyo, it did not have an occupying military force to conduct or protect investigators, to help them secure evidence, and so forth. So this means that the ICTY, and it came up this morning as a topic about how important cooperation is, the ICTY has had to work very hard to secure cooperation with its investigations so it can get broad and sustained access to actually investigate and try suspected IHL violations. So it has to secure prosecutorial support. In cases, that's one factor that's really important. However, securing prosecutorial support doesn't necessarily render the threat of legal punishment certain. So why is this the case? First off, let's see, hold on, catch up in my notes. Okay, sorry, got a little. Okay, first, international criminal tribunals cannot prosecute all international humanitarian law violations. It's simply impossible, right? So combatants might not think they would be caught. The other issue is that prosecutorial strategies vary a great deal. So as we know from the ICTY's experience, Chief Prosecutor Richard Goldstone pursued a pyramid approach where he tried to go for the lower level troops and then go up chain of command, where you had other prosecutors like Carlo Del Puente that went straight for the top. So another reason why, even if a court has prosecutorial support, that they might be able not have an impact on combatants is that combatants actually have a lot of really good reasons for committing violence against civilians. So the literature on civil conflicts tells us that hurting civilians can actually be a really useful way of securing concessions from an opponent, signaling resolve, improving a force's overall bargaining position, and so forth. So all this is to say that even if a court can secure arrests and so forth, it's by no means a foregone conclusion that they'll be able to deter war crimes. So to understand when prosecutorial support will actually play a role, you have to look at the military imperatives facing combatants on the ground. So key thing about combatants in any civil conflict is to be successful in securing their war aims, they have to secure support. In some cases, they might seek to secure support from liberal constituencies. Liberal constituencies I define as actors who care about, or at least claim to place a premium on, human rights, humanitarian norms, and they tend to support bona fide war crimes tribunals. So in cases where combatants seek support from such constituencies for their core war aims, if the ICTY were to make a determination of a suspected IHL violation or even to convict a member of an IHL violation, this sends an incredibly powerful signal that the combatant or members from his or her group are acting outside the bounds of appropriate behavior. This can subsequently result in really costly consequences for the combatant group. It can result in the withdrawal of recognition, aid, troops, and so forth. And ultimately, these constituencies, these liberal constituencies, can work with the ICTY to eventually secure even formal sanctions such as arrests and so forth. So that's the second factor. The final factor, however, that is necessary for deterrence to happen is you have to have groups or leaders that actually have control over their troops. So first off, we know that deterrence hinges on awareness of international humanitarian law. However, in my research and in lots of surveys about combatant understanding of IHL or the ICTY, lower level troops tend to be much less informed about ICTY, IHL than their superiors. So you have to have leaders that are aware of these things to be aware of the threat. And not only that, but you have to have leaders capable of ensuring that what they say goes within the ranks. And if you don't have that, we're not going to see deterrence. So just to reiterate, my argument is you have to have all three of these factors in play for deterrence to happen. If any of them are missing, we're unlikely to see deterrence. And just briefly, you might be asking yourself why liberal support-seeking leaders who have command of their forces would perpetrate violations of international humanitarian law in the first place. And the answer is that during wartime, combatants seek support from multiple constituencies, which might not all be on the same page about military strategy. They might rationalize away crimes, or they might simply think they can get away with it. So in these cases, the ICTY could essentially serve as an important wake-up call to reinforce law-abiding behaviors. My research design, again, I focus on the ICTY and I focus on its involvement in its impact on the behavior of combatant groups throughout the various wars associated with breakup of Yugoslavia. The research is based on over 200 interviews with veterans, activists, politicians, legal personnel, and so forth. I can show you my data or my interview breakdown of numbers later if you're interested. I also don't just rely on interview data or what people told me, but I also bring in a lot of primary documents collected in the field and so forth. So another thing that's really important, just because one person tells me one thing does not mean I trust it or treat it as a finding. For me to include any finding in my study, at least 3 separate people in 3 separate interviews repeated had to confirm the same event. Moreover, that event had to have some kind of justification in a primary source. So like a newspaper account, an ICTY document, something like that. We can also talk about my methods further, but I use a lot of techniques that political scientists use for qualitative research to ensure that my results are rigorous. Okay, so not surprisingly, the ICTY was not successful in deterring atrocities during the early Yugoslav wars, mainly the wars in Croatia, Bosnia, and Kosovo. Interviews, people definitely emphasized no impact, to put it nicely. Thought I was sometimes a little crazy for even asking that question. But the other thing is when you look at their behaviors, there were no impact as well. So indeed, many of us know that many of the worst atrocities actually happened after the ICTY was established and functional. And here's a picture of Srebrenica, perhaps the most poignant example of this phenomenon. The thing that's important about the findings for these cases is not that there was a deterrence failure, but why that deterrence failure occurred. And the results are consistent with the theory I just proposed. So mainly, there was a lack of prosecutorial support for the ICTY vis-a-vis combatant groups in all these cases. Moreover, even if they had prosecutorial support for Bosnian forces, for example, Bosnian forces were so disorganized and lacking of command and control, it would have been hard to have much of an impact there and so forth. So again, I can share these results with you if you are interested. The interesting case, however, is Macedonia from 2001. So this conflict is oftentimes overlooked, given the severity of earlier conflicts would be my argument. But we find some really interesting behaviors here. So first off, there were ethnic Albanian forces. There were 2 groups fighting on ethnic Albanian side. There was the National Liberation Army, or NLA, and the ANA. What we find for the National Liberation Army is that all the factors I identify were present from May onwards, and from this point we see some really interesting behaviors. So first off, interviews consistently indicated that the ICTY was in the back of the commander's mind from the spring onwards. In terms of behaviors, we see that the ICTY specifically featured in their professionalization efforts, which is really unique. Usually professionalization efforts talk about the Geneva Conventions, but don't specifically mention a tribunal. They also, top leaders in the LNA, used their respect and cooperation with the ICTY to underscore that they were a legitimate fighting force. So at the start of this conflict, the NLA was treated like a band of terrorists, and there are lots of statements to that effect. But they used their cooperation to establish their credibility. They were also responsible for very low levels of violence from May onwards. Specifically, there was a new brigade that was created with these new recruits that were kind of joined the NLA for the purposes of its credit, they thought it was a legitimate fighting force, partially because of its respect for the ICTY, and that newly formed brigade committed 0 violations throughout the war, which is interesting. Okay, then the violations that did occur took place by the ANA forces, which these 3 criteria identify were not present for that force. Okay, government forces, the factors were present from late June onwards. The interviews also indicated from the summer onwards the ICTY was in the back of people's minds, and we see some really interesting behaviors that I was really surprised about. So first off, top leaders, I repeatedly heard in separate interviews with international and domestic or Macedonian politicians that top leaders used the threat of prosecution to cool down tensions on Macedonia's Security Council as it was debating how to proceed in hostilities. They began discussing legality of ICTY, or the legality of army offenses, and an army general at a crucial point in the conflict specifically refused to carry out an aerial bombardment for fear that he would land in The Hague. And needless to say, we see much lower levels of violence by government forces from this point. Special police forces were responsible for violence against civilians, but again, the factors I identify were not in play for police forces. Okay, policy implications, the most important part of my analysis. So even though the ICTY did have deterrence failures, the thing that's really important about the ICTY is it shows that you can deter violence against civilians under certain conditions. The findings from the study are consistent with emerging research on international criminal deterrence, and I list some scholars there that you can check out if you're interested. But whether they can deter depends on some pretty important factors. So first off, it really reiterates the need for prosecutorial support or cooperation. If courts are not receiving such support, it's going to be very hard for them to accomplish anything. And the other thing that's really important is if we're going to think critically about deterrence, we really have to think about the military imperatives facing combatants on the ground and how to influence their support so that they face wider fears besides a fear of arrest, like a loss of support for being called out by the ICTY is important. So again, I'm very happy to share the more detailed findings of the project, and here's my email address, and hvala vam puno.
Thank you, Jacqueline. It was an impressive pace of speaking at the end. I could tell you were feeling my pressure, even if I was further from you. Without really too much introduction, I'm going to turn to our last speaker, Janine, who is actually going to come back to some of the issues, but addressing more in relation to issue of truth. You have the floor. Thank you.
Good afternoon, everybody, and thank you to the ICTY for inviting me to be here today. There's quite a lot of overlap to some extent between my paper and Marco's paper, but I hope to end on a slightly more positive note. I published a book in 2014, and that book was about whether the ICTY has contributed to reconciliation. And I did over 300 interviews in Bosnia, Herzegovina, Croatia, and Kosovo with all different types of victims. And my finding was that the ICTY hasn't contributed to reconciliation. And what I want to do in the 12 or so minutes that I've got today is to so I'm not going to talk about that research per se, but I want to try and suggest a solution and a way of moving forward. So I'm going to begin my presentation in a slightly unusual way by showing you this image, and I wanted to show it because if you take a couple of seconds to look at it, some of you will primarily see a white vase in the center. Some of you will primarily see two faces in silhouette looking at each other. Now, both of those visual interpretations are entirely correct. Some of you, alternatively, will look at the image and for a couple of seconds you'll see the faces, then you'll see the vase, and so on. What's interesting is that you can't see the vase and the faces at the same time. So I'm showing you this because it raises interesting questions about perception and how we perceive things. And continuing with that theme is this idea of the inverted spectrum, which was an idea that's been traced back to the English philosopher John Locke. So we perhaps assume that we all see colour in the same way, but actually the inverted spectrum says that colour exists on a spectrum and that spectrum can be inverted or flipped. So the fruit that looks red to some people, if that spectrum is inverted, could look green to someone else. Now you're wondering, why am I talking about this? What is the relevance to the ICTY? The point is that when it comes to facts, people see facts in different ways. People interpret facts in different ways, just as they see images, just as they see colour in different ways. This is significant because, as we know, since its creation in 1993, the ICTY has established a wealth of facts. And one of the claims that it makes on its website about its achievement is that these facts have helped to counter denial, and have made it very difficult for people to minimise or to dispute the crimes that occurred. But as we know, and as we've heard from my fellow panellists, the reality on the ground is far more complex, because what exists at ground level is local truths, local interpretations, ethnic truths, and the ICTY's factual truths are constantly coming up against or colliding with those more localised ethnic truths. And just to give a couple of examples, the first one is Dario Korodic, who was convicted of crimes committed in Ahmići and the Lashva Valley area of central Bosnia. When he was released from prison in 2014, when he arrived at Zagreb airport, there was a large crowd of people to support him and to welcome him home, and that crowd included some religious leaders and politicians. Similarly, when Momčilo Krajišnik returned to Pale in 2013, again, thousands of people there to support him and to show their support. So, two examples of and of course these are just two examples, there are many more, but two examples of convicted war heroes who are seen by sections of their own population as war heroes. So my argument that I want to put forward, it's often argued that facts, establishing the facts, is a really important way of bringing about reconciliation. And I challenge that argument. I want to argue that factual truths are often not a solid basis for reconciliation, precisely because they are open to challenge and contestation. But what I want to do in this paper is to suggest a way forward. And before I do that, I want to just say a few words about reconciliation. Reconciliation is a term that we often use. Sometimes we don't define it, and when we do define it, we often don't agree on what it means. We can, however, broadly identify sort of two schools of thought. And one is a thin reconciliation, which simply says that reconciliation is about cooperation and coexistence, people living side by side. A thick interpretation of reconciliation is something much more substantial. It's about people not simply living side by side, but actually living together. My view of reconciliation is always leaned towards the thick understanding, and I've always defined it as being about the repair and restoration of relationships and the rebuilding of trust. But as I was thinking about this paper, that still leaves unanswered the question of what does reconciliation actually look like. And last year, President Adjus made a speech on reconciliation, and he defined it as the process of coming together and acknowledging the past, grieving together, communicating with open hearts and minds, engaging in real dialogue, looking to the future. And I think this is a really helpful definition, because what we can extract from that is the idea that reconciliation is really about a coming together. And in particular, it's a creation of shared discursive spaces where people from different sides can come together and talk together without feeling afraid, without feeling uncomfortable. And to reiterate, factual truths, I argue, do not provide the basis for the creation of that shared discursive space. To look at this, so to lead on to what I see as a possible solution, I want to draw on the work of Gerald Goldin and his work on meta-effect. Meta-effect is effect about effect. So what does that mean? Goldin gives the idea of people on a roller coaster at a fairground. And the people are screaming because they're afraid. The roller coaster is going very quickly and there are lots of sharp drops. So they're afraid. But he also says that the people on the roller coaster know that they're safe. They know that nothing bad is going to happen to them. The ride is just going to last for a couple of minutes. So above the fear, there is a higher level emotion. And that emotion is fun, pleasure, enjoyment. People are having pleasure on this roller coaster. And this idea of meta-effect, I think, is really useful, because what Goldin goes on to say is that beliefs create meta-effect. So the beliefs that people in the former Yugoslavia hold regarding the war and the crimes that were committed are not simply individual beliefs. They're beliefs that are shaped by what politicians are saying, by what the media are saying, so those beliefs exist in a social context. But what I'm arguing is, if somebody believes that a particular crime didn't really happen, or if they believe that a convicted war criminal is actually a war hero, the meta-effect that this is creating, which sort of links with what you were saying, is they feel good for doing so. They feel that if they're supporting convicted war criminals, they're showing their loyalty to their group, they're showing that they're good Serbs or good Croats or whatever, they're showing their patriotism. And it's this, I want to argue, this meta-effect that's a big problem to the penetration of ICTY factual truths. The meta-effect is creating this barrier, and so the question is, how do we change that meta-effect and bring down that barrier? And this is my solution, which is the idea of what I call meta-normative truths. What do I mean by that? So if we think of meta-normative truths as being the yellow layer, so meta-normative truths are higher level truths. They're not factual truths. They're not about who did what to whom and when and how. They're higher level moral truths. So one example would be a moral truth about how you should treat civilians in war, a moral truth about the importance of respecting individual difference. Now, I want to argue that meta-normative truths are a much more solid basis for reconciliation than factual truths. One of the reasons for this is that they have greater processing fluency. Processing fluency is about how we process information. So if you're at a cinema and you're watching a film on a large screen, you will process that information far more easily than if you were watching the same film on a small black and white television set. And meta-normative truths are more easy for people to process or digest, precisely because they can't be politicized in the same way that factual truths can be. So my argument is that in terms of going forward, there should be a greater emphasis on meta-normative truths. What does that mean in practice? Here I want to argue, talk briefly about guilty pleas. 20 defendants have pleaded guilty at the ICTY, and these pleas have been very controversial. Many victims feel that when defendants plead guilty, they're just doing so in order to get a reduced sentence. But I think that guilty pleas have another usefulness that hasn't yet been explored, because they provide a basis for meta-normative truths. Let me give you two examples. The first example is Miroslav Bralo, who pleaded guilty to crimes committed in the Lashva Valley area. I'm not going to read the whole of his statement, but I've just highlighted the points that I think are significant. So in that statement, he talked about how he tried to be proud of his actions. He also uses the terminology of a successful soldier and a good soldier. So two really important meta-normative questions that we can draw from that are, what is a good, successful soldier? And what are the actions that a soldier can justly be proud of in war? And I think all of us would agree that killing children and killing women in war is not an action that any soldier can justly be proud of. And that's a really important example of a meta-normative truth. To give another example, Milan Babic, who was the president of the former Republic of Serbia and Krajina in Croatia, he also gave quite a powerful statement. And one thing he said is that we're all part of the same human race. And I like this point because it's linked to the South African concept of Ubuntu, which basically means that a person is a person through other people. In other words, we're all interconnected. And I think those fundamental commonalities are something that we lose sight of in war. War is about destroying those commonalities and making us all feel that we're completely different. And I think Babic makes a really important point. And he also talks about enabling our children to live in a better world. And again, that's a really important metanormative truth. All of us, I'm sure, would agree that children have a right to a peaceful childhood, free of conflict, free of war, free of bloodshed. So that's two really important examples of metanormative truths. And what I'm saying, I'm not saying that factual truths are not important. But what I'm saying is that metanormative truths provide a new, unexplored basis for reconciliation. And if there's a greater focus on those metanormative truths, potentially we can alter that meta effect and bring down that barrier that I talked about that was blocking the penetration of ICTY's factual truths. So just to conclude, the argument that I'm making actually goes beyond the ICTY. Within transitional justice, whether it be, for example, a court process or a truth and reconciliation process, the focus is always very much on factual truths. And there should be a new sort of a new exploration of an emphasis of these wider truths, wider metanormative truths as a basis for creating those shared discursive spaces that I talked about as important for reconciliation. So the ICTY is closing its doors at the end of this year. So who will take this forward? Who will take forward this idea of metanormative truths? It will be individuals within the former Yugoslavia, and in particular, I think, NGOs, victims associations, media, academics, to really promote this idea of metanormative truths as a basis for unifying people and bringing people together in a way that hasn't happened before, and organising debates. And finally, I started by saying I wrote a book in which I concluded that the ICTY hasn't contributed to reconciliation. And I also don't think we should expect any judicial institution to contribute to reconciliation. But if from now on, in addition to the emphasis on factual truths, there is a greater focus on metanormative truths that can be extracted from the ICTY's judgments, from the guilty pleas, then potentially, as part of its long-term legacy, the Tribunal can indirectly contribute to reconciliation. Thank you.
Thank you very much to all of you. We've discussed a lot of different topics, and to start this discussion, I'd like to go back to the parameters of the panel on non-judicial legacy. The parameters that the Tribunal could achieve and was intending to achieve as a court of law and had a very specific and limited mandate. That at the same time, you're dealing with one institution that had a lot of expectations to fulfill, at least to face, in the context of a post-conflict and conflict situation. And we've heard from different perspectives in terms of truth, in terms of deterrence, peace, and reconciliation. So it's a lot of food for thought. It's a lot of actually looking forward and positive and less positive, but we also always learn from the less positive. So I would like to open the floor. We have about 20 minutes. It would be great to do a couple of rounds. So maybe we can take about 3 questions first. And if you can just keep it short, and if you have a specific question to a specific person, please mention that.
Thank you. I don't think it's on. Yeah? All right, good, thanks. Thank you very much to the panel for very interesting contributions from all of you and very penetrating insights into the work as it relates to reconciliation. I have a question not so much about whether or not the ICTY can contribute to reconciliation, which, as Professor Clark mentioned, is questionable. But my question has to do more with whether or not judges and prosecutors at the ICTY should factor that into their decision-making. So let me put this question into context. It seems to me that there's a very plausible argument to say that there are limits to what legalism can achieve. And we must, in some ways, be modest about what ambitions the international tribunals or international criminal justice, not just the ICTY, but all of them, what ambitions they undertake. And there has to, I think, to be a mode of modesty about our work and what we can really achieve. In particular, reconciliation has something to do with a process that happens over time. Legal institutions are not particularly well adapted at predicting those outcomes. A legal institution may be very good at deciding what happened in a certain time, what action took place, who's responsible for that action, what factors were involved in that action. But to project into the future is something that is a perilous endeavor. And I like to use the example of Plavšić. She received a massive discount by the ICTY judges because of her purported contribution to reconciliation. She was a very senior figure, by the tribunal's own words, was convicted of a very serious crime, a crime of the utmost gravity. Yet her seniority was used to flip on its head what seniority usually does, which is aggravate the punishment. Her seniority, and combined with the notion of reconciliation, was to use to say, look, what she has said was going to contribute towards reconciliation. And she received a massive discount in her sentencing. She received 11 years, lower than the prosecutor's recommended range. Barlow, who you mentioned here, by the same contrast, had done a lot to contribute to reconciliation. He went door to door making apologies. He identified mass graves that were previously unknown. He volunteered for demining. He received 25 years sentence, more than twice what the superior was. And to me, that seems to be a very bad mark on the record of the judges who were involved in those two cases. One, Plavšić's leniency, because we saw down the road, Plavšić actually took back in an interview all of the words she had made towards reconciliation. She completely undermined it in an interview she gave to a Banja Luka TV station. So, and then when it came time for her release, the judge did not even consider that factor in deciding whether she deserved early release. The fact that she had made all these statements to undermine reconciliation, which is what got her low sentence in the first place, none of that was considered to determine whether or not she deserved early release. She was just given a standard early release after 2/3 of the sentence. So my question to you is, should judges even be considering the issue of reconciliation in their decision making? And if so, should there be some limit and modesty to how they incorporate that? Thank you.
Thank you very much. We'll take another one or two if there is any, otherwise we'll just, yes.
Yes. Hi. My question is directed towards Marco. You mentioned that even in a perfect world, if everyone did their job perfectly, that the outcome would likely be the same. But I'm wondering if you think that there would have been any difference if the outreach program would have been established earlier and had greater capacity and funding to combat some of these narratives that are passed down. If it was dispersed more widely or started earlier, would that have made a difference? No? Okay.
Thank you. Thank you. He'll go back to that. Yeah. Do we have a third one? Otherwise, I'm going to turn back to the panelists. Well, Marco, do you want to start on the last question, and then we can...
So can we imagine any outreach program that would be more powerful than Serbian state TV? Can you imagine any outreach program that would be more powerful than the official Croatian TV? Can you imagine any outreach program that can overpower state dogmas, official truths in education? There's no way to do it. So the only places where outreach worked that people really mention are Sierra Leone and Cambodia. In both of these countries, the elites that control the societies were not opposed to the work of the tribunal. That's why the outreach program could go to some random village in Sierra Leone, right? But there's no way, if you are Slobodan Milošević, that you're going to allow the outreach program of the ICTY into your country. There's just no way. So in that sense, yes, the outreach program, ideally, it helps, but it cannot overpower sustained elite opposition. There's just no way it can do that. So it can work in situations where the elites are at the very least neutral. And if you look at success stories, that's what happened. The elites stopped opposing the court, and that's when things started changing. For example, that's the story of Germany. And it was not outreach of the Nuremberg Tribunal, which was long forgotten, that made a big difference in Germany. It was various small events that somehow had an unexpected great catalytic effect. So for example, I have on my slide, I forgot to mention that, an enormous number of historians, for example, the late great Tony Judt, would tell you that, if we could revive him from the dead, that it was the 1979 Holocaust TV miniseries that did more for catharsis in Germany than the Nuremberg Tribunal, starring a young Meryl Streep, by the way. Meryl Streep did more for the Holocaust than Nuremberg, in reality. You had a telethon, you had 5 days of the entire West German population watching this very soap opera series, sort of, but directly emotionally related to the fate of a single Jewish family. You had panels of historians answering phone calls from viewers. Yeah? I mean, no court experience can replicate something like that. So that works. It's not going to work here. Yeah. Your question, what should judges do? It's very easy to criticize judges, right? We earn our keep, right? But it's very hard to put yourself in those shoes and then say, what will I do? I mean, I would have this suggestion, you know, that a judge or a prosecutor should approach their job with a sort of Hippocratic oath in mind. And that the first principle should be do no harm. So if the law allows you option 1 and option 2, and the law frequently gives a judge or a prosecutor a lot of discretion, the judge or prosecutor should choose that option that causes least harm to reconciliation. So let me give you an example, the Gotovina appeals judgment. There were many ways in which a particular result could have been reached in that judgment, but the judges who sat on that appeals chamber chose the worst possible outcome. We have a 3-by-2 divided appeals chamber overruling on the facts a unanimous trial chamber. See what I mean? So, you know, if you were a judge on that chamber, I think even if you wanted to acquit, you could have done it differently. You see what I mean? So that's, I think, the only thing that judges could do, but they can't magically reconcile people.
Thank you, Marco. I think, Janine, you wanted to contribute as well to the first question.
Yeah, just very briefly. Reconciliation isn't part, as we know, of the tribunal's mandate, and I think it would be very dangerous if the judges were taking reconciliation into account, because they're supposed to be impartial, and then they're giving considerations to sort of extraneous factors. But what I do think is absolutely crucial, of course, there have been many, many controversial judgments, and what I think is absolutely crucial is more outreach needed to occur. The ICTY has done some great outreach work, but I think much more directed at local communities, explaining these controversial decisions, because it's in the absence of that, it's so easy for the media to distort what is happening. So I think the onus was really on the ICTY to the sort of the Bridging the Gap series that it had in, I think it was 2005, more of that. Where you're going into communities and trying to explain, look, how is it that Biljana Plavšic's sentence was drastically, you know, she got this significantly reduced sentence. So yeah, so I don't think judges themselves should be considering reconciliation, but more emphasis on the outreach.
I just want to add just something very quickly. If we go back to the opening statement this morning by President Agius, reconciliation is not really in the mandate of the Tribunal for the former Yugoslavia. So, of course, it is in the back of their mind, I think, I believe. Now, I second Janine on this. I think, as I made my final statement on the presentation, I think that the outreach has done a good job at reaching out, but we need more of a localized effort to explain what is going on at the tribunal. Legalize the legalese, what we speak in the courtroom might be a little bit difficult to understand at some time. So I think that's the best effort moving forward that we can do.
Thank you very much. This also echoes back to this morning some of the welcome remarks by Serge Bramers, the prosecutor, who kind of finished emphasizing the role of civil society, both nationally but also at the international level, to kind of take forward the contributions of the NCTY to all of this. I'm turning back to you. I see one hand over.
Hello. Does it work? Yeah. I would have a question on the presentation on deterrence. I'm not at all surprised by the findings, of course, but my reading until now would have been that many people would say that the tribunal couldn't deter the commission of crimes because at the time when most of the crimes happened, it wasn't actually functioning in a way, it wasn't productive. The productive phase would have usually, I think people would say, would have started as of 2000, 2001, 2002. So if we take up the idea of Marco's perfect ICTY, would you dare the hypothesis of if the ICTY would have been a perfect tribunal as of day one, it could have had the deterrent effect, and would that be in line maybe with what you were observing in Macedonia as of 2001?
Let me just see if there's another question. Yes.
Just really goes to Marco. I was just wondering, in the light of sustained political resistance, do you think then that outreach programs are effectively a waste of time or beating your head up against the wall? Because that's sort of the meaning I'm picking up, and yet we have a lot of people pouring a lot of time and effort into these outreach programs and thinking about the next 5 to 10 years, but your assessment seems fairly bleak. Yes. So they should give up and go home? No. Is it a chicken and the egg argument then, where perhaps their efforts might slowly change opinions, or does that come perhaps from the international community putting sustained pressure on these political elites?
I think some fights are worth fighting just because the fight is worth fighting, even if you are not going to win. See what I mean? But again, if you had an outreach program from the very beginning and it had 100 times more money than it actually had, how could you do anything, right? Until Milosevic fell in October 2000, what exactly could you do in Serbia with an outreach program? I mean, what? Right? Even if you had all the money, all the people in the world, right? What can you do in Croatia now, where the purity of the homeland war is the official bipartisan universal agenda of everybody? There's nothing you can do.
So I guess I'm wondering, this is my question, are there necessary political preconditions before you start outreach programs?
I don't know.
Maybe I'll have you think for a minute and come back. Can I turn to you, Jacqueline, about the deterrence question? And then
Yeah, just a point of clarification. So the ICTY was established in 1993, but it was actually functional by 1994. It had a prosecutor, it had investigators in the field. They actually did secure an arrest and did start a trial while the Bosnian War and the war in Croatia were still taking place, so it was functional. But getting to your question about the counterfactual, which if I understand correctly, is if it had had more prosecutorial support, meaning more of a basis to actually secure the arrests and effectively try the higher ups, would things have been different? And my answer is very much yes. The top reason that all the different combatant groups from the early Yugoslav conflicts gave me for why the ICTY failed to influence their behaviors is it simply lacked international support, local support. It just really, they didn't take it seriously because they didn't think many people, anybody was going to come for them, basically. So if the ICTY had more sustained support and broad access in those conflicts, I think it could have made a difference for Croat forces in particular, as well as the KLA 98-99. The Bosnian forces, it would have been a little trickier, mainly because they were not centralized or they didn't have effective command and control during the hostilities. Serbian forces, I'm very skeptical that it would have had an effect there, mainly because they did not seek out the liberal basis of support to feel that extra kind of social pressure for non-compliance with their behavior. So I hope that answers your question. Thank you.
Did you want to come back to the other question or no?
No,
okay. So maybe just a last couple of questions. Or Deshboka, did you have a comment? No. Oh, sorry. I was pointing your way, but Go over here.
Hi, I'm David Hudson from the European Commission, so we're funding the outreach that doesn't do any good. But it does, because we're doing it. I mean, and that's the point, that, you know, there's, my family are Irish, and, there's the famous joke that, a tourist, pulls up somewhere in the countryside and says, I'd like to get to Dublin. And the farmer they're talking to says, you know what, I wouldn't start from here, right? And with outreach, we wouldn't start from here, but we are here, and we do it because by not doing it, you send a very, very bad message. So if we'd gone back 15, 20 years, then yes, certainly. I think maybe design it a different way, try and factor it in differently, try and get more buy-in from the authorities one way or the other. But we are where we are, and we do it because not doing it is far, far worse.
Thank you for those very wise words. Actually, maybe the last words. Oh, no, I see another hand. That probably will be the last question.
Good afternoon. I'm Gordana Đukanović, a journalist from Pristina, expelled from Kosovo and Metohija, and now I live in Pančevo. I wish just briefly to comment on two issues discussed here today. As Mr. Čović said this morning, we who join in the discussion shouldn't really introduce ourselves, because by what we say, you can identify which side or ethnicity we belong to, talking about the conflicts in the territory of the former Yugoslavia. Let me just say something about the contribution from my perspective, the perspective of the families of killed Serbs and non-Albanians in Kosovo and Metohija. I'm talking about the contribution of this court, of this tribunal, to enhancing the peace, sustainable peace and reconciliation. From our perspective, I may be wrong, but given that before the ICTY, much fewer prosecutions were conducted compared to crimes committed against Serbs and non-Albanians in Kosovo and Metohija, especially given the acquittals. It is our opinion that the tribunal has not given a great contribution in that regard. Secondly, let me just comment on the assistance and strengthening of civil society in the reconciliation process, again, from the viewpoint of my association. I'm talking about Serbia. I think that neither the country, the state, or international organizations have helped us or our work to a sufficient extent. And we put a lot of effort, especially my association. We tried to make and maintain contacts and good communication with the families of Kosovo Albanian victims. We are sorry that we did not meet more understanding, because this would be a good path toward reconciliation. Thank you.
Thank you very much. I don't know if anybody of you want to make a final comment. I don't see any other hands. I'd like to thank all the panelists for their wonderful and very insightful contributions. If you could give them a round of applause, and then we'll have coffee.